Hi everyone. So for today's session in the law of evidence, we're gonna be discussing the doctrine of res gestae. So the doctrine of res gestae is a term used to describe what is called the start to end period of a felony. Res gestae was once considered as an exception to the hearsay rule. This is because it concerns a declaration that is uttered so closely to the occurrence of an event that it can be used to prove that the event actually happened. Further, because a statement made under the doctrine of res gestae is made naturally and spontaneously, there is little room for misunderstandings or misinterpretations by anyone who hears it. Therefore, if a witness were to testify and repeat such a statement to the court, that statement could then be used as evidence. Court hence believes such statement to be thoroughly reliable. The doctrine of res gestae statements can fall into one of the three categories. Number one, words or phrases that either wholly or partially explain a physical act. Secondly, exclamations that are so spontaneous that they can prevent anyone from successfully lying to the contrary. Third, statements that prove an individual's state of mind. So, if we look at if the statement made by some witness falls under these three categories, then the doctrine of res gestae will be able to cover them. In some jurisdictions, res gestae has also been used in connection with the admission of sketches the police draw of potential suspects. The most complicated area of criminal jurisprudence is the tool of proving what type of evidence is presented for proving in court of law. Here is one of the principles of law of evidence is res gestae. The doctrine of res gestae is based on the assumption that every relevant part of the chain of the event is considered before the final disposal by the judiciary as under criminal justice system so that no evidence can be discarded on the ground of irrelevant consideration even if some technicality is also differs from case to case. Moving on, the reason behind for this adoption is that the doctrine of res gestae under the criminal law as the necessity of proving some relevant fact. It is not possible for proving the whole incident without helping of some missing facts. It may be proved by some other piece of evidence examined and titled as doctrine of res gestae. Res gestae is a Latin phrase which means that forming part of the same transaction. It means that relevant portion of that event which is connected directly or indirectly with the main transaction of the event. The meaning of doctrine of res gestae is unclear and it is not definitive. It is so confused term as we cannot say that what is exactly considered as doctrine of res gestae. It is not stated clearly because it is the discretion left to the courts to consider the relevant evidence based on the whole facts of the cases. Moving on to the history of res gestae. So the rule of res gestae was first appeared in the case of 1963 in Thompson versus Terravanian, where it was held that declarations accompanying an act are receivable in explanation thereof. In the year 1736, in the case of Ambrose versus Glendon, declarations were again held to be admissible if concomitant with the facts. Then the use of doctrine of res gestae was in a brief discussion over a point of evidence in Holmtruck's trial for high treason also. Nevertheless, the development of this doctrine did not begin until after Evanson versus Lord Kinnaird in 1805, where the phrase in question has begun to be freely used in connection with it, and only since the middle of the 1800s has it been possible to say that this exception was firmly established. In the infamous decision of Cockburn Chief Justice in R versus Bedingfield, the principle of res gestae, an exception to hearsay rule, was discussed. Lord Justice Cockburn held that the statement was not admissible since it was something stated by her after it was all over. He said that it was not part of the transaction, that it was said after the transaction was all over, the transaction being the cutting of the throat. Although this decision has been effectively overruled, it accurately illustrates the erstwhile principle used to define the res gestae exception, which often resulted in unjust consequences. Actually, the decision of Beanfield case was too strict. However, this decision was overruled in the case of Ratton versus R, where under common law the doctrine of res gestae was defined in liberal and wider terms. Another case, Ratton versus Queen, Lord Wilberforce said evidence would have been admissible as part of the res gestae because not only was there a close association in place and time between the statement and the shooting, but also the way in which the statement came to be made. In a call for the police and the tone of the voice used showed intrinsically that the statement was being forced from the wife by an overwhelming pressure of contemporary events. Moving on, the doctrine of res gestae under Indian Evidence Act. So the section 6 of Indian Evidence Act explains the principle of res gestae. Hearsay evidence is not admissible in the court of law, but res gestae is an exception to the hearsay rule. The rationale behind this spontaneity and immediacy of such statement that there is hardly any time for concussion. So such statement must be contemporaneous with the acts which constitute the offense or at least immediately thereafter. Moving on, res gestae includes facts which form part of the same transaction. So it is pertinent to examine what is a transaction, when does it start and when does it end. If any fact fails to link itself with the main transaction, it fails to be a res gestae and hence inadmissible. If any statement is made under the stress of excitement, then such statement from part of the same transaction and is admissible before the court of law. The strength of Section 6 lies in its vagueness. Each case in criminal law should be judged accordingly to its own merit. When it is proved that the evidence forms part of the same transaction, it is admissible under Section 6. But whether it is reliable or not, that depends on the discretion of the judge. Thank you.